I'll start off by saying thanks to David Goodsall. Basically, I started on my legal journey many years ago, which you can see I'm very old. Started my legal journey, of all things, by attending seminars at the Australian National University run by Matthew Rimmer. So, a sign of, if you like, sort of respect for moral rights, David Goodsall provided the rather frightening or entrancing image there of a virus. Regrettably, it's not a COVID virus. Dr. Nathan will probably be able to tell you which virus it is. Anyway, so I'll get on to the business. Okay. So pandemics, unlike patents, gift us with insights about ourselves: heroism, incomprehension, creativity, selfishness, and privilege. If we're fortunate, they help us to understand how we make sense of the world. Presentations today look beyond rhetoric about intellectual property and international cooperation, or non-cooperation perhaps, and they suggest that COVID offers some rather disquieting answers about a misplaced faith in TRIPS exceptions and the willingness of governments in the north to meet the needs of people in the south. One conclusion might be that although patent law is not inexplicably flawed, COVID illustrates fundamental problems with the design of TRIPS. Those problems centre on the capacity of governments, north and south, to use Johar as it was ostensibly intended. Today I want to talk about something a bit different, remembering that we're heading up to the centenary of Lord Acton's landmark tort and consumer protection judgment in Donoghue and Stevenson. As a reader of Patrick Attia and Martha Minow, much of my research has sidestepped grand theory about intellectual property, has instead addressed the here and now, in particular regulatory capture and regulatory capacity regarding health goods and data. In the next 20 minutes or so, I'm going to accordingly offer a rather sideways view of TRIPS and access to essential medicines. I'm going to talk about consumer protection, the exchange of secrets principle, and questions of trust. In essence, there's little point in having a strong or a weak patent regime if consumers are discouraged, possibly in the next nudging, if they're discouraged from using the protected pharmaceuticals. And there's also a little point if our fear prevents our neighbours from accessing both knowledge and the medications generated with that knowledge. So let's start with consumer protection, specifically the operation of Australia's Therapeutic Goods Administration, otherwise known as the TGA, or irreverently, if you're a consumer advocate, irreverently as Fortress Science. The TGA is Australia's counterpart to the FDA, other overseas pharmaceuticals and medical device regulators, coexists with a range of bodies in Australia. So coexists with the Australian Competition and Consumer Commission, with the Food Standards Australia and New Zealand, with research by Ken Harvey, for example, who's now an adjunct at Bond, accordingly noting regulatory arbitrage regarding oncology products. The TGA is part of the Health Department rather than an independent entity. Its focus is on product safety rather than efficacy. This is quite important. Now, COVID has arguably been the TGA's brightest moment in the past 30 years. There have been significant achievements. And in response to criticism by consumer advocates, it has indeed scored some wins, notably action against Pete Evans, this marvellous machine, and Lorna Jane over anti-COVID leotards. Not much effort or courage, because we've talked about courage and creativity today. Not much courage or effort was required to remind people that designer spandex on your butt is less effective than population-scale face masks and vaccination. Now, the TGA has had some successes with other easy targets, such as the quantum physics bionic air plasma machine that supposedly prevents oldies like me from getting COVID. And it's a mere $2,000, so of course we'll buy one. And that device, regrettably, is still on sale, just without reference to the pandemic. The vendor selling Faraday cage armbands that purportedly stop the Beast 999 from tracking you via the RFID chip injected in your arm during mandatory vaccination somehow hasn't been bolstered by the TGA. The TGA has joined the chorus condemning Clive Palmer's reported donation of 5 tonnes, a mere 5 tonnes, of worm medicine, and more importantly, it has somewhat belatedly embraced social media. In some ways, this is quite revolutionary for the TGA. It has embraced social media, but albeit less effectively than Mr. Palmer, Craig Kelly, Gerard Rennick, and George Christus. And those achievements, and this week's federal court decision regarding very related action against Oxymed, interesting judgment there that's worth reading, should not dissuade us from a hard-headed critique of the TGA, a regulator that is regrettably a manifestation of regulatory capture and incapacity by design. The TGA operates on a cost recovery basis, oriented to minimise the costs experienced by businesses seeking authorisation for the sale of health goods, pharmaceuticals, medical devices. COVID has been a reminder that although some businesses are small, the market for drugs and devices is dominated by very large multinationals. And you might ask, how large? One example is Pfizer. I saw a picture of someone from Pfizer today. Pfizer, which is forecast to have cash and marketable security, so equivalent cash, of around $59.5 billion by mid-22, that's up from $29.7 billion at the moment. Now, that's Pfizer's private piggy bank, by the way. It's not its annual sales, it's not its market value. It's how much cash they can reach into its pocket pocket and pull out. And when we look at the data, much of that money will be spent on acquiring competitors, startups, some of the time, rather than on in-house research. And this is the same model. If we're picking up, say, some of Matthew's research over the last couple of years, it's the same model that we see being used by Facebook, Oracle, and Alphabet. Much of their innovation is not done in-house. It's done by buying someone else, buying someone new, possibly buying a competitor. So my contention is that without causing the multinationals to completely avoid Australia's small but it's rather attractive market with strong patent protection, low corruption, low inflation, a history of solid payments, we could reasonably ask suppliers of therapeutic products to pay just a little bit more for regulatory approval. It's a reasonable business cost, the cost of doing business. That increase wouldn't break the patent system. It wouldn't cause the drug giants to go home or invoke ISDS action or indeed persuade Joe Biden not to sell us those marvellous submarines that won't arrive apparently for another 30 years or so. 30 years by which time we hope that COVID will have gone away. It would enable the TGA to build capacity in ways that should prevent harm and to build trust in the broader regulatory framework. Now, whether you're an economic rationalist or a dignitarian committed to facilitate human flourishing, you should actually be keen on that capacity building. We have problems with the TGA. We have a history of systemic regulatory failures regarding a range of implants and other problems. This history also follows the TGA's refusal over many years to meaningfully engage with the community rather than with people within a magic circle, and the TGA's often visceral hostility to legitimate criticism. Now, that refusal was an express policy position that it's a matter of paternalism and administrative convenience rather than simply underfunding. It disregards the opportunity to build social capital, a social capital that could be drawn on and indeed should be drawn on in handouts, sort of thing we've just heard with the previous presentation. It's especially egregious because the TGA is uniquely immunised from litigation. Basically, the TGA will not get into trouble. It can't be sued unless you can prove that there's been some sort of malicious intent. Incompetence, not a problem. Immunized. And this is a interesting, I would argue, inappropriate form of discipline. So I've specifically referred a moment ago to economic rationalists. because irrespective of the profound and avoidable suffering experienced by thousands of Australians, that regulatory failure in recent years has imposed an avoidable billion-dollar burden on national productivity and the public health system. And that cost there, that burden, is more than 10 times the TGA's budget. So we're talking about something that's visceral, something that's quite tangible. A penny-wise, pound-foolish approach has real-world costs. It's not an abstraction. And underfunding the TGA does not make costs disappear. It simply transfers them to people where the costs may be unbearable. Now, the latest COVID variant, the one that we're particularly interested in at the moment, reminds us that there are similar costs if we don't care for our neighbours. Non-supply of vaccines to much of the global south, and indeed the north's ongoing indifference to non-COVID health problems in the south, will foster future pandemics that directly impact on lives and jobs in Australia. And that non-supply is a matter of vaccine nationalism and logistics. Remember, we've had difficulty meeting our own needs. It's also a matter of the failure of international negotiations over the past 2 years to reach a timely outcome, akin to an agreement not to have a meaningful agreement about climate change. We've heard about that, I think, quite appropriately today. Now, that outcome might have involved acceptance of the use of the TRIPS waiver. It might more positively have involved patent holders actively licensing their products. They'll still make enough money to continue to exist. They'll still make enough money to innovate. Now, I mentioned that the TGA is immunised from litigation. The dominant vaccine vendors in meeting community needs for vaccine development and supply have sought immunisation for themselves, immunisation from harms attributed, reasonably or otherwise, to their products. In times of crisis, that protection is indeed reasonable. My contention, however, is that the protection should be accompanied by a requirement to share test data. Let's have some transparency, let's have some openness. Yes, you do indeed get statutory protection, with all the opportunities for egregious rent seeking by the likes of Martin Shkreli, the Pharma Bureau. You do get a longer than standard period of protection, remembering that pharmaceutical patent protection is typically longer than the standard 20 years. In return, however, you disclose the basis of your invention, you disclose test data, and you actively assist regulators in the reporting of harms. And given the notion that sunlight is the best disinfectant, a notion regularly ignored by the national government in dealing with ICANN and freedom of information, we might actually ask for more. We have responsibilities. We might, for example, in collaboration with other governments, insist on transparency regarding the pricing of central medicines. Now, I'm thinking here in particular of indications that vendors are charging quite different prices for vaccines, something that's a difference, if you like, that's not justified by research, manufacture, or distribution costs, and insisting that the different governments treat each price as secret. Seem like a multinational in a time of crisis, to adopt James Scott's great book on Seem Like a State. Seem like a multinational times of crisis is advantageous when you're dealing with desperate politicians and with officials who've been trained to understand the world through the eyes of those they regulate. As a legal pragmatist, I'm going to wrap up by offering a few modest proposals, possibly in the veins of Jonathan's speech. A few modest proposals for change, drawing on submissions to the TGA and parliamentary committees over the past decade. The latest parliamentary committee report on therapeutics regulation featured the usual claims that the period of patent protection for drugs and medical devices should be extended, possibly extended radically, in order to provide a better incentive for the development of orphan drugs and, buzzword of the month, precision medicine. Now, there's no persuasive data that extension will indeed be beneficial or fair, and regrettably, it's rare for industry advocates to acknowledge that much innovation was in fact on the back of publicly funded research. From a consumer perspective, patients, taxpayers, neighbours, people like us, we shouldn't be extending the period of protection. We should be seeking to capture the benefits of public funding in a more equitable way. We might also establish the TGA as an independent agency, depoliticised by reporting directly to Parliament and without incapacitation through ongoing productivity developments, in other words, ongoing cuts, death by 1,000 cuts every budget, and inability to engage in substantive cost recovery. Independence would foster a more positive corporate culture at Fortress Simonstone. We've talked today about corporate cultures, UN, WHO, and so on. A more positive corporate culture at the TGA. That culture change will be founded on recognition that the TGA exists to serve consumers rather than product vendors, particularly vendors without a major domestic presence and who, presumably, rely on mechanisms such as the Dutch sandwich to minimise tax liabilities. Now, I began by mentioning creativity referred to licensing by the pharma giants. Medical research is one area that hasn't been established by government that's currently desperately scared that people will start writing dissertations about Jane Austen. Apparently, we're not scared about writing dissertations about Carl Schmidt. Now, Australia does need to strengthen its research and development capability on an ongoing rather than the usual stop-start basis. The government currently accentuates regulatory incapacity, regulatory inadequacy in the public sector by outsourcing to businesses such as KPMG. My modest proposal is that incapacity on the part of the TGA might well be offset by using that very same separate model. Why not outsource services to life sciences faculties in Australian universities? I'm sure we have that here. And even possibly to a law school or two, admittedly with a somewhat swifter turnaround than what we're currently seeing from the ARC, if you believe some of the noise on Twitter. And building a distributed capability across universities, across the Australian jurisdictions, would strengthen the institutions and would allow the re-employment of the invaluable technical staff who have been shed in cuts over the past 3 years. That re-employment would strengthen Australia's vital skills base in the metropolitan centres. Now, next Monday is the deadline for responses to the TGA regarding its consultation regarding the potential for medical device adverse events reporting. I might be forgiven for rolling my eyes just a little when I suggest that the consultation is so very, very overdue, with all their lives broken, dollars wasted through avoidable disasters, and alas appears designed to get the answers the health department wants rather than what Australia actually needs. What we need is a coherent, timely, comprehensive, and thereby effective mandatory reporting scheme regarding problems with therapeutic goods per se, rather than just high-risk devices. Data generated through that scheme should be readily accessible for independent scrutiny, should be kept in a black box. Thomas Tyler famously argued that people obey the law because they perceive the law to be just, rather than merely because lawmakers have sanctions to compel compliance. We've heard about compliance. Law is ultimately a matter of trust. Now, in responding to pandemics, and I would argue in going some way to avert pandemics, we need people, blasé, frightened or otherwise, to obey rules, to trust advice, to be responsible in dealing with their neighbours. Australian governments have increasingly underfunded and undervalued secondary education, a disregard that isn't hidden by trolling about cultural Marxism. And in underpinning both patent and consumer protection law, we need to strengthen both a fact-based curriculum and a curriculum that emphasises responsibilities alongside rights. And that's one way, I would suggest, because there are many ways. That's one way of addressing COVID denialism, or the narcissism that your death is an acceptable, possibly inevitable part of my paranoia or a consequence of simply of your nationality. You're not a worthy person, so you should die. You're an acceptable cost. We could hope for a TGA that deepens our understanding by proactive outreach to consumers rather than its traditional, we only talk to industry and sub-practitioners mode of communication. Why not respond to worm medicine devotees with a fact-based medicine influences of your own? And given that ministers apparently pride themselves on their prowess marketing ahead of policy, we might hope, and via the ballot box, indeed require a political representation in which leaders are swift to strongly and consistently denounce no ifs, no buts, no Peter Evans coconuts, to denounce figures who espouse fake health news out of either ignorance or self-interest. The marketplace of ideas fails when the Prime Minister fails to robustly and quickly condemn George, Craig, Clive and Joe. And finally, returning to ex-Queensland boy Lord Atkin, in thinking about COVID Snails policy bottles that shouldn't be opaque, we might remember that we cannot expect the least developed countries and the BRICS to be good neighbours if we fail to either make trips work for a global community or we fail to provide support outside of the intellectual property framework.